Welcome to our channel. Today, we're exploring the unique legal status of cap and ball and muzzle-loading firearms under federal and Texas law. Stay tuned to learn why these fascinating firearms are treated differently and what this means for collectors, enthusiasts, and even those with criminal records. According to the Gun Control Act of 1968, antique firearms, including those made before 1899 and their replicas, are not classified as firearms. This means cap and ball revolvers and muzzle-loading rifles often fall outside the typical firearm regulations. Federal law exempts these antique and replica firearms from modern firearm regulations, allowing collectors and enthusiasts more freedom in ownership. Federal law defines antique firearms as any firearm manufactured on or before 1898, or any replica of such a firearm, provided it is not designed or redesigned for using modern ammunition. This exemption means that these firearms can often be purchased and owned without the same requirements for background checks or licenses as modern firearms. Texas law aligns closely with federal law, defining antique firearms similarly and offering similar exemptions. Cap and ball and muzzle-loading firearms that are replicas of pre-1899 designs are not subject to the same regulations as modern firearms in Texas. This means they can often be sold and owned without the need for background checks or firearm licenses. While ownership of these antique and replica firearms is less restricted, it's important to remember that modifications and carrying them in public can still fall under different regulations. If a replica or antique firearm is modified to use modern ammunition, it may then be classified as a firearm, and subject to all relevant laws. Additionally, the open carry and concealed carry laws in your state can impact how and where you can carry these firearms. For individuals with criminal records, particularly felons, the legal landscape is more complex. Federal law prohibits felons from owning or possessing firearms, but since antique firearms are not classified as firearms under federal law, felons may be able to own and possess cap and ball and muzzle-loading firearms. However, this is not always straightforward. State laws can vary, and some states have specific restrictions that may still prohibit felons from owning these types of weapons. If you're a felon considering owning an antique or replica firearm, it's crucial to consult with a legal expert to understand the specific laws in your state. Texas law defines firearm in a way that excludes antique and curio firearms manufactured before 1899, or their replicas, provided they do not use rimfire or centerfire ammunition. This means felons may legally possess these antique firearms under Texas law, but always verify local regulations and consult with legal counsel to ensure compliance. Beyond legal considerations, owning and using these historical firearms can be a rewarding hobby. Whether you're interested in historical reenactments, collecting, or simply appreciating the craftsmanship of antique firearms, understanding the laws surrounding these weapons ensures you can enjoy your hobby responsibly and legally. Thank you for watching. If you found this video helpful, please like, share, and subscribe to our channel for more insightful content on firearms law and history. Have questions or suggestions for future videos? Leave a comment below. See you next time. Please note that this video is for informational purposes only and does not constitute legal advice. Always consult with a qualified legal professional regarding your specific situation.